spread over various states, various tribunals, both at the state and center, advanced ruling authorities, and Securities Exchange Board of India, securities appellate tribunals, and other forums. Before I hand it over to TaxSutra's group editor, Arun Giri, who shall set the context for today's session, I would like to take the opportunity to apprise you all that in the last few minutes of the session, we will host a dedicated question and answer session. For this, you may post your queries in the Zoom question and answer chat box. With this, I now hand it over to Arun.
Always a pleasure to welcome Venkat sir to our webinar. The moment this judgment came out, we put it out. You know, at times you miss the thrill of being in the Supreme Court, as I used to be for the Vodafone case. 28 days to cover the matter. You know, me and my colleague. Then I still remember entry tax matter, which I was there for almost 3 or 4 weeks to cover the arguments. And it's always been a privilege to cover, sir. Very, very few lawyers in this country who can traverse direct tax, domestic, corporate, international tax, then indirect tax, on which he is a master. And that's, I could call him the maestro, like they call, the revered Ilayaraja for music. That Venkat sir is for indirect tax. I think he must have surely argued more than 500 to 1,000 cases on indirect tax alone in the High Court and Supreme Court. So this is why we said this webinar aptly. I think we called it the final word on this judgment. And I'm not going to take more than a minute and a half, because I know everyone wants to hear from sir today. A lot has been said, a lot has been written. The political class, the punditry, as well as tax and legal experts have all ventured, dived into this judgment, even before a copy of it could come out, even before the nuances could be understood of the 153-page judgment authored by Justice D.Y. Chandrachud. I have seen this 12 years back when Justice Chandrachud was pronouncing his order judgment in the Bombay High Court Vodafone tax case. Until almost 80% of the verdict was read out, everyone felt in the courtroom, and I was a journalist in the TV channel, that taxpayer has won. It's only in the last 20% of the of the pronouncement we got to know, oh, but there is a catch here, and this is exactly what's happened in this matter. So the 148th page of the judgment, I almost felt while reading it, and while we were all working on the summary, it felt like Justice Chandrachud had passed a judgment in favor of the revenue. Only I felt, had we misreported something? It's only in the last 10 pages that the whole case turned around. But otherwise, almost on every conceivable point that had been framed by the Supreme Court as a question of law, the revenue won, and Venkat sir argued the matter. But what made headlines was not the point itself. The 140 or a substantial part of the judgment was devoted to IGST on ocean freight, but that's not what has made the headlines. What's made the headlines is the Supreme Court's observations on the binding stroke non-binding nature of recommendations of the GST Council, its observations on federalism, dual federalism, cooperative federalism, and a lot has been said about it. So much so that even Justice Chandrachud himself, one of the senior most judges of the Supreme Court, one of the most erudite judgments that you'll read, he himself remarked in the court to senior advocate Harish Salve, another luminary who also appeared in this matter on the other side, of course, on the SSC side. He remarked, even I am surprised by some of the articles and the way they've construed this judgment of the Supreme Court. Venkat sir authored an extensively read article, a 7-page article on this judgment the very next day for TaxSutra's GST portal, GST Sutra. And I'll just take 10 seconds to read and set a context for what would be an equally fiery and impassioned session by sir. In that piece, sir did say, any assumption that any one of the players, that is the states, can pull the strings or set the teams their own way, and in the process emasculate the equal rights of the rest, nowhere deal with any part of the judgment. He further goes on to write in this piece, there is not even an iota of reference, suggestion, or comment on the manner and functioning of the GST Council in the judgment. Any other inference is simply destroying its founding principles. Of course, sir was magnanimous to congratulate the other side, the SSC side, for its verdict on the IGST on ocean freight on the point of composite supply. Venkat sir, everyone waiting with bated breath for your dissection of this judgment, for your nuanced understanding of this judgment. Of course, there are various views. We call yours view the final word, but everyone still, it's a free country. Everyone still will venture to have their own views. Pleasure again to have Venkat sir talk at the Tax Sutra webinar. Additional Solicitor General of India, a large-hearted person who does extensive and extraordinary philanthropy, including running a Veda Pathshala in Tamil Nadu. Venkat sir, over to you.
My dear Arun, Vinita, Tax Sutra team, my beloved colleagues in the bar, tax professionals, chartered accountants, and those who have logged in from the trade. Am I audible and visible, Arun? Yeah, thanks. I mean, I saw the topic in its fine print only now. I realize he has put it as the final word. I mean, I don't know. It can't be the final word, definitely. I only wish when the talk ends, at least a few of you say fine word, if not final word. So my request is, I'm going to divide the speech into two parts. I'll spend only 5-6 minutes on the other aspects of what the judgment has said. I don't want to be dwelling on it. So many people have done webinars and they have discussed it threadbare. So I don't want to lose focus. The main focus of today's talk is going to be on what has the Supreme Court opined actually on this binding nature of the recommendations of the GST Council, because reading the newspapers, various other social portals, electronic media, and also statements here and there, at least I can say with all humility, the opinion ranges from total ignorance, possibly because of not reading the judgment, to malicious intentions, possibly after reading the judgments. This is the bandwidth of opinions that had filled the public domain on this subject. That's why I wanted to wait for some time and did not want to speak immediately, because let's see how far each one travels in this journey to express their thought process. So when Arun asked, how long will you take? And so that we have a question answer, I said, I will talk for 40 minutes, but I'm going to ask only questions in the 40 minutes for those who have wrote and those who have spoken. It's going to be a few questions raised out of sheer humility. Please address these questions and then say what you have, whether your opinion still stands the way you have discussed and projected in public domain. So before we venture into this binding nature of recommendations, as Arun was saying, which also I wrote it in Tax Sutra, there are 4 or 5 issues where the revenue has succeeded on the aspect of extraterritorial levy, on the aspect of who is a service recipient, on the aspect whether notifications are valid, on the aspect whether delegated legislation is, in this case, is sustainable, on the aspect of consideration, and so on and so forth. On composite supply, the court has comprehensively held against the revenue and in favor of the assessee. And therefore, the net result is assessees have succeeded because there is no tax levy. On the composite levy, I have only one viewpoint. I don't want to be debating on that at the moment. The viewpoint is, the court has the bottom line of deciding why it is a composite supply is, court says, when union has argued that section 39 of the IGST Act allows, as long as the goods have their destination directed towards India. When the destination of the goods is towards India, then it is a sustainable levy in the hands of the Indian importer under 13(9). So when this is the contention of union, then how can union argue that when it comes to the actual contract, there are three contracting parties in this case. Let's say the seller is in South Africa, the shipper is in, say, London, and the importer is in India. Goods are in London, seller is in South Africa. So he contracts with the shipping line to ship the goods from London to, say, Bombay port. So the contract between seller and the shipping agent, A and B, is one separate contract. And the contract between seller A and the importer C is yet another contract. If you see the definition of composite supply, it uses the expression service by a taxable person. So it is the taxable person's composite supply which is amenable to tax as one bundle. Now, the taxable person is not merely A here. What is being taxed is the reverse charge of B in the hands of C. One. And the transactions are, the shipping transaction is anterior to the subsequent sale transaction by the South African seller to the Indian importer B, C. Consequently, is it the law that anterior contracts, when they are destination based, should now be read as composite contracts? This is the doubt and concern which revenue has today. Is that the law? If you see section 13(9), even though it is destination based, it does not put forth the condition that it should be a composite contract. Nor does it deem, because it is destination based, all contracts will be bundled into one. It doesn't say so. So destination based is in terms of its location for the purpose of taxation, whereas composite is in terms of bundling. So whether both should be integrated or not, the court has now integrated. That's the law today. We should bow down to it and respect it. But these are the doubts all of us are, at least in the revenue side, are discussing it. So we will leave it there. Regarding the rest of the issues, we have succeeded, and therefore I don't want to be deliberating about it. People have talked pros and cons of it, which they are free to do in various webinars. So let's not reinvent the wheel again. So what is the net result of this case? It's like, as I wrote in Tax Sutra, it's like a CA student actually passing all the exams individually, but has still not qualified the threshold average required. And therefore, he has been declared failed. That's the state of revenue in this case. But we should still congratulate. It was such an illuminating experience, at least personally for me, fighting 6 senior counsels and 6 to 7 very prominent young aspiring counsels, 12 to 13 of them on the other side for over 1.5 months. It was a great journey, great learning. I thank all my friends on the other side for giving me the opportunity to learn a lot from each one of them. Thank you so much. Now we come to the firing part of it. See, what do we understand from the judgment? I have a few questions for us to ask. The first question I want to ask people who have wrote this many articles, have they read VKC Footsteps, which was also a judgment authored by Justice Chandrachud, and read Mohit Minerals, both together? And after reading both together, does Mohit Mineral anywhere say 279A6 of the Constitution is redundant, it is superfluous, it is simply some sort of a guidance, it is unworkable, it need not be followed? Is there any such ratio emanating from this judgment? So first question I pose to people who have written a lot of articles and who keep speaking about it. On the contrary, paragraph 48 of Mohit Minerals, the present judgment, I go with the paragraph as reported in the website of the Supreme Court. It says, the GST Council must ideally function as provided by Article 279A6 in a harmonized manner to reach a workable fiscal model through cooperation and collaboration. So I want those who have voiced their views to make a note of it. Has 279A6 been diluted by Mohit Minerals? Because we have to go by fundamentals. We can't be taking some stray sentences here and there from the Supreme Court and twist it out of context. So, in my humble view, I say this with sense of responsibility and dignity. 279A6 has been reaffirmed and reinforced one more time in Mohit Minerals. And it has not been diluted or found to be unconstitutional or found to be redundant or irrelevant. Now we move to the next question. The same question I asked all of them. Have you read both VKC and Mohit Minerals before expressing your views? When both these judgments record that there are three distinguishing features in the GST regime under Article 246A, namely, the field of legislation and the source of power is embedded in the article itself. You don't have a separate schedule, like list 4. 2, it is a simultaneous levy. And 3, both union and states together have joined hands towards federal cooperation. Now, in Mohit Minerals, it has expanded the concept of simultaneous levy and distinguished it from concurrent levy under the constitutional scheme, because the first Mohit Minerals on cess did refer this as concurrent levy. That's why when I argued VKC, I told the court that this is not a concurrent levy. There is a significant difference under our constitutional scheme. In English, they may be the same. But in Constitution, a simultaneous levy is distinct from a concurrent levy. And what is the distinction? It has been brought out very eloquently by the learned judge on the court in the second Mohit Minerals judgment, which you are discussing, saying that in a concurrent levy is subject to the repugnancy test under Article 254. Both can legislate, but if something is repugnant, then center's view will prevail. Whereas in a simultaneous levy under 246 capital A, both has to go together and levy on one taxable event as they identify together. And there is no repugnancy test under 246A. I want the viewers to kindly register this in their mind. The judgment very clearly says no repugnancy in simultaneous levy in contrast to the concurrent levy. Now, what do your articles say? What does people in public domain say? Look here, from tomorrow, every state can legislate anything it wants. Anybody can pass any legislation they want. I'm asking a question to my dear friends. Which paragraph of the Supreme Court judgment says, no, Article 254 won't apply, no repugnancy, but we have evolved a theory, states can act in repugnance to GST Council's view and do whatever it wants to do. Has it created such a constitutional power through this judgment? Are we going to read such things into this judgment? Where has this judgment said so? I'm just asking my friends, because you're all saying you can legislate from tomorrow. There's no need to go and attend the GST Council meeting. So when court is very cautious about the repugnancy test and says it is absent in a simultaneous levy, how could pundits say, no, it is very much present and present in favor of the states who can act in complete repugnancy to the union? Tell me, my dear friends, where do you get it from this judgment? Which para says so? In what context are we reading this judgment? So this is the second question I pose to all of them. Now the third question is, what has the Supreme Court recorded in paragraph 38 of its judgment. This is a speech given by the then finance minister, late Arun Jaitley sir. Note the date, 8/8/2016, after which all the states have unanimously passed this law as 101st constitutional amendment. And what was he saying? He was responding to a question posed by Tamil Nadu, my state. And the Supreme Court in para 39 records what the then finance minister says. What has he said? Once you get into the GST pipeline, the states and the center will have to interact together. And once they interact together, the state of Tamil Nadu will be involved in determining and taking decisions relating to the states. So, none of us is going to be surrendering his or her autonomy or authority. We are both going to be pooling our sovereignty together so that we are able to create a new taxation mechanism. What is the basis or genesis according to the Supreme Court by extracting para 39 of this GST? The genesis is pooling of sovereignty and not surrendering of sovereignty. So articles in public domain keep writing. The surrendered power can no longer be retained by the GST Council. Where? Who has said states have surrendered their power? Which constitutional provision says so? Because ultimately it's the respective union and the states who have to legislate. The power of legislation is still only with union and states. But there is a difference. In every other law, you are independent and you act independently. Whereas here, you have submitted yourself to a process called a pool sovereignty. Pooling of sovereignty, where do you pool it? You have pooled it only in a council, which is a constitutional body called the GST Council. You have not pooled it anywhere else. Having agreed to be part of the pool in through the process of 279A, which is a constitutional amendment, having agreed and passed a resolution in your own state, agreeing to this constitutional amendment, is it open for anybody to take a stand which is unconstitutional or anti-constitutional? This is the third question I pose to my friends. How can you be part of a pooled sovereignty process in a constitutional body and also say I can act independently in my own free will? How do they coexist simultaneously? Go to the fundamentals before we just want our aspirations to be our views and not what Supreme Court says. I want my friends to answer fundamental questions from this judgment and from constitutional law. So 246A and 279A breeds a new doctrine, new philosophy. That's why the court says it is sui generis. There is no comparison to it. And it's called the pooled sovereignty process. See, the nearest comparison we showed. See, we worked on this for several months before arguing in the court. We have given the expression used recommendations in 34 places in the Constitution. And it can be classified in 5 different groups. Everything is found in the judgment. You can see for yourself. What are the types of recommendations? What precedes it? What succeeds it? Everything we have analyzed it. The court has done it based on our submissions. So, pooled sovereignty, show me one comparison in the Constitution of pooled sovereignty anywhere else. That's why the court says it is sui generis for the first time. And the closest was the Interstate Council. And Interstate Council under Article 263 very clearly says whatever policy it decides is for the general good and which is only to communicate. That's why court says that recommendation is a non-qualifying recommendation category. It's a non-recommendation. It falls under that. Supreme Court decides the status of Article 263 in this judgment and contrasts it. So, in a pooled process, once you are part of the pool, how do you say, no, I can also be outside the pool? I can be part of the pool, I can be outside the pool, I can toss off a coin, I can decide whether today I should be part of the pool, tomorrow I should be outside the pool. Where does the Constitution permit you? You are talking, I am free to legislate. You are given your commitment. It's a constitution. It's not simply, see, constitutional trust is a doctrine. Whereas this is a constitutional mandate. And you are a party to that mandate. When there is a constitutional mandate saying we are all together, how can you say I can be different? Which provision of law gives you that benefit under the Constitution? And which part of the judgment says, do you think a judge of this caliber who is so renowned could have ordered judgment which is unconstitutional? What are we finally imputing? And a judge is expressing his views in open court. I'm really baffled. What is happening? Intrigued. Why should he say that? You're ultimately subscribing a view which is not there in the judgment and which is not there in the constitutional scheme. So this is the third question I pose to my friends. Fourth question. When Union and all the states have passed unanimously the GST 101st Constitutional Amendment, whether Constitution is supreme or acts are supreme. I'm just putting a very fundamental question for you to. Can you ignore Constitution and decide things on your own? And does Constitution say you have surrendered your sovereignty? To say that the surrendered sovereignty has come back through this judgment. When did you surrender? Who asked you to surrender? How did you surrender? We want to know. So, this is the fourth question I pose to my friends. The fifth question. See, when the 101st Constitutional Amendment came into place and it was voted all over unanimously, special sittings were convened by state legislatures. They ran a special session for this and they passed these resolutions unanimously to be part of it. Two significant changes were made from the original, from 2011 to 2014 to 2016. Every legislative history is captured in this judgment. Every legislative step has been captured in this judgment. Two significant changes have happened. One, when the original bill suggested in 2011 that every decision in the GST Council has to be unanimous and consensual, the standing committee, finance standing committee said it is not going to happen. It's not possible. And therefore, we should make it voting. And they originally said a simple majority. Then the standing committee recommended, no, it's not going to work. It should be 3/4. And 2/3 will be in the hands of the state and union will have 1/3. So that both union and states gel together in the decision-making process. One cannot exclude the other. It is so well interlinked. The dependency is at a constitutional level. The interdependency is blessed constitutionally. Now, when you vote, I want to know where are we taking this judgment to? If you are going to substitute our own views and inspirations and aspirations, if somebody votes and that voting as a decision is sent as a recommendation through a pooled sovereignty process, you will say that is not binding in your own way. Supreme Court has said something is not binding, certainly in this judgment. But we must know what is not binding carefully. It has said, I'm not running away from that. I'll deal it. What has it said as not binding is equally clear from the judgment. There's no ambiguity. Now tell me, in a voting process, after a decision is taken and a recommendation, what should be the status of the recommendation? Now, has the Supreme Court in this judgment said, this voting process has no validity? This voting process has no sanctity? Has it said so? I want to know from my friends. Please tell me, where has it said, which sentence of the judgment, which para of the judgment has said this? Now, the Second Amendment is, instead of appointing, adjudicating authority on disputes, they have very well conceived 279A11. Any disputes shall be resolved in a manner, in a mechanism to be devised by the council itself. Why? Because it springs out on the principle of pooled sovereignty. So, I just want to ask my friends, 279A, subclause 11, is it part of the Indian constitution or it's part of some Latin constitution? I want to ask that question. If you agree it is part of Indian constitution, any problem has to be resolved through the council only. How can you resolve it independently? To say, I have a power to legislate, I will therefore legislate jolly well my way. I care two hoots to 279A11. Can anyone take such a stand under the constitutional scheme? None of these articles, speeches, statements, views have dealt any of these aspects. That's why I'm putting all these questions. So are we now saying, according to us, are we saying this bench of the Supreme Court has said 279A11 is now stuck? It's no longer in the constitutional scheme. It has been stuck once and for all. So states are free to do anything. Has it said so? Has it said so? Which para? Which line? Which sentence? Show us. Now, having asked these 5 questions, therefore, my request is whoever wants to log in and ask question answers, please let's not, you are entitled to add few more. I have no problem, whichever way. But I would like first to know answers to these fundamental questions. Now, next question is, several articles, why was this argued? Where was the need to argue this? Where was the need for the Supreme Court to decide this? So they will advise what Supreme Court should hear, what Supreme Court should decide. When the Constitution empowers that it's the final court which can give a judicial verdict. So why should revenue take this point? Why should union at all argue this? Why should there be a sermon on this? All this they're asking. Therefore, union is duty bound to clarify why it was argued first. It was argued because the assessees argued the following submissions. And it was also part of the Gujarat High Court judgment. What did they argue? A, it is extraterritorial. And because it's an extraterritorial law, only Parliament can pass legislations. You can't be issuing a notification. And two, independent of this, the Gujarat High Court has also declared these notifications to be ultra-virus and unconstitutional, even for added reasons. Therefore, it became necessary for the Union of India for the first time to bring out an important aspect. What is that important aspect? GST Council is a sua generis forum. It's a pooled sovereignty forum. And the forum in which sovereignty has been pooled is also a constitutional body called GST Council. And look at the way this was what was argued, and it is captured in para 58 of the judgment. What did we argue? We are not here to decide the supremacy of the legislature or the parliament over the GST Council, or the supremacy of the GST Council over the parliament or the legislature. We have argued neither does Article 246A nor does 279A says notwithstanding or subject to. Both have not been used in this article. Therefore, neither 246A can claim supremacy over 279A, nor can 279A subordinate 246A in any manner. So what was argued is, we have now gone beyond the era of supremacy. We are in an era of alignment, because there is now a constitutional body where union and states have aligned through the process of pooled sovereignty. First venture at a constitutional level. So let's not walk the path of supremacy. Let's walk the path of alignment. And alignment is a philosophy. I have to show how it has aligned. So we demonstrated before the court, both the parliament and the states in unanimous, uniform way have aligned themselves essentially on three aspects: charge and taxation, Section 5 of the IGST Act; exemption, Section 6 of the IGST Act; rule-making authority, Section 22 of the IGST Act. Similarly, you can go for CGST, SGST. There are parallel provisions where it is not surrender, it is pool. It is not surrender. Nobody argued surrender. You can take my written submissions. Not a word has been whispered as surrender anywhere. It's 110-page written submissions. So, because of pooling, you reach a constitutional theme called alignment. And what is your alignment? Parliament and state legislature says these are all areas which are very, very critical for uniform taxation. Therefore, we will align with the recommendations of the GST Council. Based on the GST Council, it says, it uses the expression in their own statute. I am not talking in thin air. You can go and read the provisions yourself. So, having aligned yourself to 279A, the recommendations which come to you, should it be held binding or not? Para 59 says, after recording this, after referring to what we argued in 58, Para 59 says, what was before the Supreme Court was a secondary legislation. That is notification. It was not on legislation. The case we argued was a notification. So it said the secondary legislation recommendations are binding. Not one person has anywhere said that Supreme Court has also said what is binding. They're all very happy to write what Supreme Court has said, not binding in their own way. Interesting. And people who don't read this few lines or statement, don't read the whole judgment. And they are led to believe. So it says this. Now it doesn't stop there. I'll give you the paragraph numbers at the end of the speech. It refers meticulously, the judgment refers meticulously and classifies 279A into two broad buckets at the first threshold level. 279 capital A, subclause A to G as one category. And if you read A to G, all these three referred alignments will fall into that. Because that is all this law is. Taxation law is only about that. These three alignments will fall into A to G. I want my friends who spoke about pulling out and writing legislatures, tell me which paragraph the Supreme Court has said 279 A to G is not binding. Show me one sentence. So it first classifies, takes that out. Then it refers in para 50, para 52, para 54 as what? There is also a residual power to the council, 279A H. Any other matters relating to GST. So that's the second bucket. After classifying the second bucket as any other matters relating to GST, it further subclassifies it. How does it subclassify it? In para 50, yes. In para, see, all my friends have written a lot of articles on para 47 to 48. Uncooperative federalism and marble, layer cake, marble, and therefore contestation federalism. Everyone has said so many things about it. This is what Supreme Court says. Contestation federalism, uncooperative federalism. When it comes to contestation federalism, my dear friends, this is what Supreme Court has cautioned each one of you before speaking at para 49. It says, if the states have been conferred lesser power, they can still resist the mandates of the union by using different forms of political contestations as permitted by the constitutional design. Not as assumed through an unconstitutional process. You read contestation federalism with this limitation first, before I answer other questions which are much easier. Now you are talking so much about uncooperative federalism. There are paragraphs they have extracted from textbooks saying that in a democracy, evolving democracy, uncooperative federalism will lead to cooperation. All that is there. They have referred to authors, they have referred to literature, everything is there. After saying that, why should Supreme Court in paragraph 48 say, refer to the constitutional bench judgment in NCT Delhi and say, India follows cooperative federalism? So if you are so happy reading 47 to 50 the way you want, why don't you also read the limitations embedded in that 47 to 50 first? How can you take that out and read it in your own way? Now coming to the second bucket, 277AH, which is the second bucket, which says any other matters relating to GST, how Supreme Court conceives in after 47 to 50, 47, 48, 49, 50. These are the critical paragraphs of contestation, uncooperative. The last final word of para 50, what does it say? This is what it says. The GST Council is not merely a constitutional body restricted to the indirect taxation system in India, but is also an important focal point to foster federalism and democracy. So it breathes into 279AH. Other matters need not be restricted. Other matters relating to GST in the constitutional scheme, Supreme Court reads, because it's a converging federal body, it's a pooled federal system for the first time. It's possible in that because of it says plural party, multi-party democracy, multilingual democracy, all size everything. Therefore, there is a possibility for this platform to foster federalism and democracy. After 47 to 50, whatever you felt is so inspirational for the states against the union, it finally concludes like this. It talks about all this 47 to 50, nothing to do with the taxation system. It feels GST Council can also be this body at some point of time. And that body can foster federalism and democracy. All right. 52 to 56, it talks about recommendations. Now, please read, my friends, you come to the conclude the ratio paragraph of what is not binding. What is not binding? One. What is not binding? So everybody is reading para 54. This is what is most of them quote. Para 54 says, the notion that the recommendations of GST Council would transform into legislation in and of themselves under Article 246A would be far-fetched. So it uses the expression transform into legislation, uses the expression far-fetched. So everybody is catching this sentence to say, look here, now recommendations cannot translate into legislations. It is far-fetched, Supreme Court has said. My dear friends, with folded arms, you are reading the last sentence of 54. Why don't read the opening sentence of 54? It has ring-fenced. What has it read at 54? The GST Council, which is a constitutional body, is entrusted with the duty to make recommendations on a wide range of areas concerning GST. The GST Council has plenary powers under Article 279AH, where it could make recommendations on any matter related to GST Council as Council may decide. It is drawing its ratio not on 279A as a whole, 279AH. And this is what it says at the end of 54. Legislations under H. Okay, what are the legislations under H? Para 50. What does para 50 say? Para 50 says, the GST Council is not merely a constitutional body restricted to indirect tax system in India, but it's also an important focal point to foster federalism and democracy. So, should there be some recommendations outside the indirect tax system, which has an impact on democracy, which has an impact on federalism? Don't think and read. That will automatically become a legislation because it's a recommendation by the GST Council. We are not asking for that. Union is not asking for that. We are very well, fine. How does this sentence give you the right to say, I will unplug myself from all the constitutional themes? I'll take this one sentence and say 279A has been junked. 279A has lost its significance in law under the constitutional scheme. Is that not far-fetched? Or what you feel is what we are expressing opinion today is far-fetched? I leave it to you. I leave it to the wisdom of each one of you. What is far-fetched? When Supreme Court very clearly ring fences and it deals only with clause H. It doesn't deal with A and G to say non-binding nature anywhere. Show me a sentence or a paragraph. It's a challenge I pose to my friends. And in H, it qualifies in para 50 that GST Council is a body beyond indirect tax system. And you can't say any recommendations or views expressed on fostering democracy or federalism should transform into legislations. You can't say, no, GST Council has recommended, therefore it should become a law. You don't say that. That is not binding. How do you say your rates, your law, your legislations will all not binding here? Is it fair? So my time is up. I think I exceeded 7-8 minutes more.
Not at all. So there are some questions.
I'm ready to take any number of questions, but I would like to have answers for the first 5 questions and the explanation given on what is binding and what is not binding. I can take questions, no doubt. Let somebody come out and say everything, whatever you have said is wrong. And show me paragraphs from the Supreme Court to say whatever you have said is utter nonsense. I'm throwing a challenge to my friends, not with any arrogance, not at all. Please, I say this with utter humility, with folded arms. Please read a judgment completely and understand it, assimilate it, and do whatever you want to do.
We already have a remark here. So analysis of para 54 is excellent, puts the whole issue in perspective. So please continue with any binding on time. I'm not going to eat up. There are some good questions, sir. But can I take the moderator's privilege and ask you the first one, and then Vinita will of course moderate the Q&A. As the Supreme Court has remarked, while Justice Chandrachud is known to compose his judgments well, it's also important to understand how a particular judge writes his judgments. Justice Chandrachud always composes his judgments in parts and vivisects the issues. So when we were talking about the GST Council itself, so he's talking only about the GST Council, the learned judge. While talking about the GST Council and federalism, Justice Chandrachud also talks about simultaneous legislative power framework. Sir, would you just want to, just maybe in the sense federalism, cooperative, dual federalism, everything has been talked about, and you mentioned, emphasized beyond any doubt or beyond any further need for affirmation on the concept of pooled sovereignty, which is what I think the late Finance Minister, Mr. Arun Jaitley, kept on saying in Parliament. This is about pooled sovereignty. So how does the simultaneous legislative power framework work in conjunction with pooled sovereignty? Is my...
There are two sides of the same coin. Unless you pool, you cannot emerge into a simultaneous era. And you can't continue with your simultaneous era the way you have been continuing for 5 years unless you remain in the pool together. So it's a good question according to me. It's a very, very apt question. You can't say, I will be part of the pool, but not follow 246A of a simultaneous levy. Nor can you say, I don't want this simultaneous levy anymore in my life. And therefore, I can't be part of this pool. You have constitutionally agreed and amended the law and you are a signatory to that amendment. Your state legislature has passed it. Now, unless there is a constitutional amendment to it, reversing the situation, okay, no more pooled sovereignty. All of you are independent. You can have ununiform taxation. How can you reverse it? And to say that the judgment has done that, I mean, it's very saddening, sir. It's absolutely saddening. And especially of a council, which is a performing council. And see, let me put this angle for your question. This is my answer also. Why did we emerge as a pooled sovereignty on what? We have not pooled our sovereignty on environment or water or forest or river. We have pooled it for the sake of trade and business. Imagine that. Whom are we now staking? Your own philosophy and fancies. Who is going to be the loser? The underlying trade and business. I'll ask only one simple question. The 7th question to my friends. Has any trade body, has any VIP businessman in this country has expressed any view to say, no, whatever is expressed in the public domain is an excellent view. And that is the view Supreme Court has said. That is the view we will follow. They are all rattling with these ideas. If you're going to put them as pawns and stake on them for your own ideas, whom are we staking? See, every time, 10 years back, what people used to say, you lose business to your neighbor because you did not have a uniform taxation on goods and services. You have triumphantly achieved it today. And somebody wants to reverse it. And do you think trade is going to say, yeah, you want to reverse it? Very well, we are all with you. You reverse it? Why? And which part of the judgments allows you to do that? Is the question. So, good. Simultaneous and pooled sovereignty gives birth to simultaneously. That's the answer.
Yeah, Vinita, over to you.
Yeah. Sir, on these lines, I'll take this first question. Are there examples of pooled sovereignty anywhere else in the world for us to compare and evaluate?
Now, there are federal systems which work on pooled sovereignty, and the dimensions and the distinctions are different. Each one works. There are, in fact, close to us is a Canadian one. Australian is again a federal setup where there is pooled sovereignty. We have derived this from very many constitutions. But remember, India has its own peculiarities. Each is all because it's size of the country first. Every time we compare with Singapore and say Singapore is developing, Singapore is even smaller than Tamil Nadu. So you should compare apples with apples. Yeah. So when you do that, the test of the pudding is in the eating, Vinita. Tell me two things. I can ask 200 questions in favor of GST. I'll ask only two questions for want of time. Tell me, during which period have we clocked 1.7 lakh crores revenue in a month in indirect taxation? Tell me.
Never, I think.
Second question. Today we are discovering fake invoices running to 10,000 crores, 40,000 crores, 20,000 crores. Do you think all fake invoices came because of GST? They have always been there. We could not identify it in the past because we did not have the technological system. Today, I just want to know if somebody wants to pull out your GST system, what will you do with your GST? You can't log anything. You will be on your own world. The trade is so well niched. And see, from all the states have agreed from originating state to consumption state. Why? Because when you allow from destination to consumption, over a period, it will take time. It will take 20 years. But over a period of time, there will be a spread that every state will have a revenue generating mechanism. A consumer of car in Bihar will take the tax. Will it benefit Bihar or it will benefit the manufacturer? So we have moved into this era to have an overall growth, uniformity, and to keep saying we can do whatever we want to do. Whom are you staking? And to say Supreme Court has aided such a line of thinking at the cost of the trade, very unfortunate, absolutely unfortunate.
Thank you, sir. I think it will address the question. The next question I can take from Mr. Prashant Deshpande. Why the service tax matters on ocean freight, which were originally tagged with GST, detagged and still pending?
Assessees requested it, therefore it was detagged. And you don't have the benefit of composite supply in old service tax regime.
Yeah, and there is no such concept.
So I don't know whether assessee will now insist for a hearing or I don't know. Let's wait and see.
Okay. Vinita, can you take a question from Mr. Vasant Bhatt?
Vasant.
Senior indirect tax professional. Yeah.
Okay.
Vasant Bhatt here.
Yeah, Vasant Bhatt.
Yeah.
Import on CIF basis involve only one contract between importer and the seller abroad. The importer does not have the importer is not privy to any other contracts which the seller may have. In such a case, how can we say it involves more than one contract and hence it cannot be a composite supply?
See, I mean, I don't want to be deliberating now because we are also studying it and we are working our options on that. So I don't want to be deliberating much on this. But today is the verdict and we respectfully bow down to the verdict. And our concern is this will have ramifications. So when you read composite supply from a service provider, a taxable person, to superscope multiple taxable persons into composite supply is not part of the GST scheme. I will leave it there because we are exploring it. We don't want to be discussing this and we bow down and respectfully say this is the judgment as on date and we take it.
Okay. Can refunds be claimed retrospectively with effect from 2017 or just 3 years back only in view of Mafatlal judgment?
To follow Mafatlal is 9 judges. So you have yourself said that in the question Mafatlal. So follow Mafatlal.
So only 3 years.
Follow Mafatlal. I leave it there. If I say 3 years, tomorrow I may contest for something else from different paragraph. I don't want to be saying. Follow Mafatlal. Let both of us follow Mafatlal.
What will be the outcome for FOB transactions?
No, let's wait and see. In fact, I would request, it's a request. I don't want any diversion of this talk, even in the question answer session, outside this constitutional, because it's really concerning. It's really, I'm thankful to Arun and good turnaround again, like 90,000 notices were cashed in 148. So we had a good discussion and I mean, things are happening well there. Now, I'm happy you gave us the platform to speak and it's a good number have attended it here and also in the YouTube. And at least a few will see it after it's uploaded also. So therefore, I don't want to take anything else in this session.
Sure. So we respect that. So yes. In line with it, I'll ask
the talk should not get diluted at all.
Not at all. So one question is this judgment going to be reviewed by a higher bench or a curative petition being considered? What businesses should do now? Should not the government come with some clarification for the industry?
Now, one thing, we are very much concerned about the trade and business. Union is really concerned about trade. And I can say this with a deep sense of responsibility. Absolute responsibility, we say. And please do not ask us the options. We are examining and exploring a lot of options. But we want to resort to the action which is of least resistance and enables ultimately trade and business not to suffer. Okay, that will be our endeavor. And at the moment, I don't want to commit a particular course of action. It's all under contemplation. So, but we will have to see, according to us, there is no need to act, technically speaking, because the judgment has very clearly divided A to G in one and dealt with H. And in H, it has qualified itself that it deals with federalism and democracy. And only, it's very clear. But when, see, there is a story in our Puranas. A man walks on the street with, say, 2 dogs. The first man who meets him says, "Why are you holding 2 asses on your hand?" He said, "Look at this. This is the dog. Why are you saying it's asses?" Then he walks. The second man says, "Why are you walking with 2 asses?" Then, "Look at this. This is dog." The third man says, the fourth man says. So when the fifth man says it, the fellow who is actually holding the 2 dogs gets a doubt. Are we holding dogs or asses? This is our Puranas. Why this is cited in the Purana with this example is falsehood has enormous power. When you repeat the same line of thinking which is not correct, 10 people say it, you tend to believe it. It's human nature. I will believe it, you will believe it, especially when we don't read it fully. Therefore, because it has created so much of confusion, we are not confused. We are clear. But because it produces confusion in public domain and it has an impact on trade and business, we are concerned. As union, we have a responsibility to our, we are doing well. Post-COVID recovery, show me the rate of growth of various nations and where we are today. So we need to extend our gesture to our trade and business. And therefore, what we need to do, we will do. Certainly we will do. But even though we are clear, There is confusion amongst many. And therefore, for the sake of that confusion to be clarified, whether we should act in a particular line, we'll come back on that. Certainly.
Yeah. So a couple of questions. I think you already answered this, but I think these are yes or no questions. One, under present GST law, can any state legislature make some provision or change rate on some specific item which may be different than the other states?
In fact, the Supreme Court is so concerned about it, it has referred in 3 paragraphs, including the paragraph where it says binding at para 59. So if states are still going to do something like this, well, they are breaching the Supreme Court judgment and the constitutional mandate.
Yeah. The second one is, in what ways states contest as per the Constitution against the GST Council's recommendation? Para 50.
So therefore, even though I will read that passage again to my friend who has raised this question. Para 47 to 50 deals with contestation, deals with uncooperative. These are the 2 terms. See, layer cake federalism, marble cake federalism, uncooperative federalism, and contestation federalism. These are the 4 catchy words which our friends have taken and elaborated here and there in their articles, in their speeches, in all. So I'm talking on para 47 to 50 are the 4 critical paragraphs. What does the Supreme Court say after all this, reference to all this text in para 49? With reference to contestation federalism. It says, if the states have been conferred lesser power, they can still resist the mandate of the union by using different forms of political contestations as may be permitted by the constitutional design. So you can't go and meekly submit yourself. You need not have to. You can raise your views. And in fact, I don't want to be deliberating on this much because we do not know how we are going to say and when. After the judgment, I had a long talk with people connected to the council and how it operates. See, none of us have any idea how it works. From morning 10 o'clock to night 11 o'clock, people sit and discuss here. To say that only 15 committees' recommendations are just given how many meetings have those people sat, witnessed it? I want to know before making all these statements. How many meetings have they attended in GST Council? So, and look at the record of history in 5 years. How many times it has been unanimous? How many times there has been a disagreement? Do you have a statistics with you? People who have spoken in public domain, do they have statistics? So how could you make such statements?
I think in the last 4-5 years, there may have barely been a couple of occasions
where
there was voting. Yeah, barely.
See, everybody is concerned about trade and business here.
Yeah.
That is why I said this experiment is not on river, not on environment, not on forest, not on wealth sharing.
In fact, if it also, there's been so much criticism about GST, in general. But one thing that I think, and we've stated that repeatedly in so many webinars and conferences, that you have to give credit to the GST Council just for the alacrity, the speed, and the responsiveness to industry concerns.
And see, any constructive suggestion we are willing to see. For example, I may not be entitled to say this so strongly, but I'll just give a couple of. See, Tran 1 was a big issue for 5 years. When I took it up and we found 8,000-9,000 writ petitions pending, we sat with the council and we exchanged 2-3 very nice deliberations. And I said, see, why are we looking at this from this? They had their own views very clearly. Sir, if we do this, this is what will happen. We also find what, and we have come to some consensus now in solving the problem. It's 4 years old, no doubt. But somewhere, the end of the tunnel, there looks to be some light. In some form or way, we want to help. We have said this also to the Supreme Court. We have requested them to post the matter in July. And we have assured that we want to do something. So, when you are trying to solve problems, and we are ready to see if there is something which you can do, come with an idea which can help the nation and which will not lead to leakage, and it's going to be more practical and simple. We give you the assurance, please send it to us. We'll put our foot strong if it's going to benefit trade. See, don't think people sitting there want to write a law against the trade or screw the trade. There might be mistakes, because as you do not know what is happening in GST every day, they may not also know what is happening at the possible. Let's understand it that way. So if you can bring out something which will promote national interest and not result in leakage, certainly we will examine it and see what best is possible.
Last question by my good friend Prakash Sinha, and then Vinita, in case we have time, we could take one more, but I think this should be good enough. What can be the reason of removing proposed 79B? How will the dispute of GST Council be resolved?
No. In fact, the judgment records it as part of legislative history. If you have that dispute resolution mechanism, then the question will be, what will be its status? Again, we have already enough problems with our friends with GST Council, Quas, Parliament and State Legislation. So we'll be inventing one more. And they found out it's a two-step process. See, it's so beautifully done. You should give it to the... See, we should congratulate every state for being part of this pooling sovereignty. It's a wonderful concept. After 1956, 6th Constitutional Amendment, where based on 7-judge bench in Bengal Unity, where CST law was drafted. A CST, 7 judges said, center should have jurisdiction. Till such time, nobody should tax. Evolve a law. And the law came and it was approved. After that, it's a historic triumph to everybody with 25 years of experiment. 2 decades of experiment has culminated in the GST model. So what they have said, they have done 2 things. They said consensus won't work. You can't say every time it should be unanimous, because we are a big country, difference of opinion will come. So don't go by consensus, don't by voting majority. But how is your voting majority? 3/4. How should it be split? 2/3 to state, 1/3 to union, so that both have to be together. Every resolution should involve both union and states. Union can't exclude states, state can't exclude union. It's interdependency. And in spite of that, should it be a dispute anything, after all this protection, then allow the council to resolve it itself. Don't take it to any other body. So you start and stop everything within, because it's a constitutional body. It's not some private, it's not some statutory creation. It's a constitutional body. So start everything there, discuss everything there, resolve your differences there. What a wonderful scheme. And that is why I asked, has Supreme Court in this judgment said 279 capital A 11 is struck off? It is invalid, it is nullity, it is unenforceable. You can do anything. Has it said so? And why do you make then such subscriptions?
Sir, I think we can take one more question. It is not related to tax, but it is an interesting question you might want to answer. With the possibility of huge migration business coming to India from China, do you think these interpretative views trying to create a false narrative leads to economic instability?
See, you are now driving me to answer it politically, which I have been avoiding for 1 hour and 15 minutes. I wish to actually answer this. Had I not been ASG, I would have actually addressed this question more comprehensively. And I would request only a politician should answer this question, because trade will be more convinced if a politician answers this question rather than a professional answering this question. Whoever has asked this question has finally nailed this case. This is
Mr. Hari Chandrasekharan.
Whoever it is, this is exactly what we should have avoided. That is why I made a statement very humbly at the beginning. The kind of voices or views that are getting voiced in public domain ranges from total ignorance, not reading the judgment, and at the end of the spectrum, malicious intention after reading the judgment. the bandwidth is so huge, Vinita. And whom are we finally doing what? Let politicians answer it. Let this discussion remain only professional. That's my request. But I have answered broadly what it wants to convey.
There are a lot of questions on ISG, IGST on ocean freight and refund, but sir has very clearly said he's not going to be dealing with that part. So we'll keep.
Why? Because Arun, after you uploaded the YouTube on 148A,
there
are a lot of viewers after the session. And so many people wrote to us. So after this, I don't want this to be diluted in any other form. This talk only to be focused on this.
Sir is referring to a Tax Sutra webinar on the reassessment judgment of the Supreme Court. The 148A, right, sir?
After you uploaded, more than 1,400 people have seen it and they all responded.
Absolutely. So
therefore, I don't want to dilute this talk.
Sure. So very well taken, sir. No questions on ocean freight matter. Sir has very clearly said that everything is being examined at a suitable time. Maybe something will come out from the government side. So we'll not probe, sir, anything beyond that.
Before you thank, let me thank my very good friends who have been listening and supporting this talk, and also my dear friends who wrote. There is no personal animosity, nothing. We are taking positions, and therefore we have to defend our positions. Okay, and the concern is we should not say something which is not in the judgment. We should not say something which can damage our trade and business, and we should not say something which will not only damage our trade and business, but enhance the prospect of somebody else. Yet, especially when the judgment is not aimed in that direction, nor has the judgment said anything in that direction. So that's why I wanted to ring fence it with these concluding words. Let's not play and stake on our trade and businessmen and do something which is not good and detrimental to them. It's a very polite request. And I once again thank all of them, and see, it's freedom of expression. You're free to do. But when you voice a view on a judge, if you voice your view on a philosophy, that's different. When you voice a view on a judgment, we should have that constraint with us or that restriction. We should not be voicing something which is not there in the judgment. It's very elementary.
In case any of you all have missed our coverage of the ocean freight judgment of the Supreme Court, on which we've been listening to for the last almost 100 minutes, log on to our GST portal, gstsutra.com, and so maybe one of these days we look forward to some conferences in Mumbai and Delhi to hear you in person. I still remember those conferences during the GST, when GST was just being launched, conferences across the country that we did, and you're so kind to participate in some of them. It will be fun. Hope to restart that soon. And thanks so much, sir, for your time. I think once again, an absolute exposition on an important judgment from the Supreme Court. I'm sure a lot will still be said, a lot will still be written, talked about this judgment. But I think Venkat sir has very forcefully and very passionately delivered a nuanced view of the Supreme Court judgment over the last 100 minutes. He's taken almost all the questions on the GST Council part, the observation Supreme Court has made on that, and hopefully this will put a quietus to this talk.
But mine is not the final word. To that extent, there's a disagreement on the topic. Pleasure to have been with all of you.
Thank you, sir, and thanks everyone for logging in on a Monday evening this webinar. Once again, a full house. Thanks so much to all our patrons for making it here. For coverage, day-to-day coverage of our portals, you can log on to taxsutra.com. We have portals on direct tax, transfer pricing, GST, corporate law, and much more. Log on to taxsutra.com for day-to-day unrivaled coverage on anything and everything to do with tax, the world of tax. Thank you, sir. Thanks so much. Thanks, everyone. Thanks, Tanaya. Thanks, Vinita. Thank you.
Thank you, Arun. Let me log.
Thanks, sir.